You can see from the PC she doesn't want to go forward, and she's indicating on the PC that no battery ever occurred.
Just call it Mr. Antaeus Allen. Hey, good morning, sir. You're being represented by Mr. Weeks. He's in our courtroom. You're charged with domestic battery.
Did he sign the paper?
And,
I did this way before that.
do you have any comment about probable cause? I mean,
Judge,
I
read it. The victim's indicating in the police report that Mr. Allen never touched her. That, in fact, she indicates that the bleeding was caused by some drugs that she had previously used. So I would indicate to this court that there's no PC in reference to the battery.
Well, it says here, detectives advised the defendant was observed in the driver's seat delivering punches to the victim who was sitting in the passenger seat. When the police got there, they said her face was full of blood.
Roselle.
I'm going to go ahead over defense argument and find probable cause. Did you have a chance to contact her?
Yes, Your Honor. She did confirm that she is having car trouble. She is not in fear.
She's not in fear. State, does she have any criminal record?
2008, trafficking MDMA, possession of marijuana, resisting without violence. 05, possession of marijuana. 04, tampering with evidence, possession of marijuana, resisting without violence. 04, felony possession of marijuana.
Do you have any children?
What's let me see here. I'm going to give a bond, not put the lower end based on the facts, but what's she do for work?
Judge, I don't know, to be candid with you.
Now, can we just ask him a couple questions?
Sure, go ahead.
So what do you do for work right now?
Handyman.
Okay, how long have you lived down here in South Florida?
30 years.
Okay, do you have any money in the bank?
Not as right now.
Sir, I'm going to go ahead. I'm going to set your bond today based on these facts at $2,500. Based on your criminal record, I'm going to order, though, you have no contact directly and indirectly with Lisa Pike. Don't contact her, don't call her, don't text her. Stay 500 feet from her. You're not allowed to possess guns, firearms, or ammunition while you're on release. All right? Thank you.
Yes, sir.
Judge, thank you.
Can I see you real quick? Not about this, about something else.
Are you going to hire your own?
Ma'am, which patient are you on this one?
Page 21, Adir Mendez.
Dear Mendez.
Hey, give me paper.
Portuguese. Can we get an interpreter? You just go ahead with it.
What's he saying?
We could go ahead, unless you have a specific...
Mr. Mendez?
I got it.
Mr. Mendez, do you understand what we're doing here today?
Yes, sir.
Okay, good. We have an attorney for you right over here, sir, all right? minutes on your
We're calling a a Portuguese interpreter for him.
Okay, you know what, do you have 5 minutes we can get the interpreter?
That's fine. That's not a problem, Your Honor.
Did you already call Portuguese?
We tried. They hung up on us.
Thanks. We're gonna take care of that.
That's not a problem, Your Honor.
You know, I found that when I read that, I knew there had to be a backstory to that whole thing. Go ahead.
Nothing on this case.
Gracias.
We have
Gracias. Obrigado.
co-defendants on the docket are here from a refile. I was hoping we could possibly deal with it just to get it out of the way.
Okay.
It's Brigida Daniels.
Oh, Cabrera on 16 is also Spanish.
Okay. Portuguese interpreter.
Well, get the case called out of turn. Okay.
You know what, ma'am? Here's where we are.
Because I'm sure you've seen the reports.
Joshua.
His
Does
wife
he know
is
you're
telling me
here?
that it's based off of work that
Jim
he
Lewis?
performed for this gentleman.
You're Judge FG, I think that changed.
Well, I don't think we'll call back. Here's the, we don't have a Portuguese interpreter today. We probably won't have
for the
one
case.
until tomorrow.
Okay.
So
What time?
would it be better that we just proceed and try to get him out of jail today
Please,
with a
Your Honor.
bond, or set him tomorrow and get a Portuguese interpreter?
I would prefer we just handle it right now. He takes daily medication.
Now, step forward,
See what
sir.
happens, but I just
Come on up a little bit. There you go. How's your English? Is it very good?
Understood.
Okay. So, he has a very minor criminal record.
Yes, Your Honor.
You know, I don't know.
And in response to your question, is for subcontractor work for 2 sets of properties that he paid for the gentleman.
Right.
Ok, tú no me respondiste la pregunta. Si vas a pegar un abogado, quieres ayuda de Estado.
So I'm gonna set a minimal bond for him. Who's gonna bond him out?
Bill's here.
His wife.
His wife. I'm gonna set his bond $2,500. All right?
Thank you, Your Honor. I appreciate it.
Yes, ma'am. Let me just advise him. Sir, I don't want you to have any contact with Michael Cornora.
Ivan.
Don't have any contact with Michael Cornora. Do you understand?
Yes, sir,
Yes.
Can I say something?
Okay.
Yes.
Just when you get a chance, tell him just don't go around the
Thanks.
guy. Stay away from him. All right?
Oh, yeah, I'll let him know.
Okay, ma'am. Thank you for coming in today.
Thank you,
all
Your
right?
Honor. I
Sorry you had to
appreciate
wait a
it.
few
No,
minutes.
it's not a problem. Thank you. Take care.
Mr. Jello, may I help you?
Judge, how are you? May I call Rashad Lateen? It's on your domestic violence docket on page 3. I spoke with Mr. Linder this morning. Mr. Lateen has no priors except possibly a misdemeanor cannabis, I think, right? Is that right,
a
Mr.?
couple of misdemeanor cameras.
Aggravated battery and false imprisonment. Do you have any issues about probable cause today, Mr.?
I would raise a question on the false imprisonment. I would have to consult the statute. It says that she wanted to go over to the hospital, as you read, but I don't know if that rises to the level of false imprisonment.
Ultimately, the defendant contacted. See, after the victim's statement, she should plead with the defendant, take her to the hospital. Drive south in Dade County to the city of Homestead. I don't know, maybe.
It's, well, one, Your Honor, it's a filed case.
Oh, okay.
2, yeah, if someone says, especially after suffering an injury where it turns out their arm is broken and their elbow dislocated, obviously they want to go to the hospital. They won't out of the car. He continues to drive around. He's not letting her out of
So
the
I'm going to
car.
find probable cause to both counts. I said he grabbed the victim by her left arm with such force that it fractured her arm and her elbow was dislocated. Boyfriend and girlfriend for 6 years. She remained hospitalized for 3 or 4 days, right?
A couple days, it says.
Couple
Judge, there was my understanding from speaking to families that there were a couple other individuals in the car. This is domestic in nature. That we all know that there's different things that go on with these types of cases. Again, he does not have substantial or significant priors. His mom is here. He does not stay with this young lady, so we're just asking for a very low bond.
Where's the mom? Can she come up, please? Ma'am, will you raise your right hand for me? You swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, put down your hand. Tell me your name, ma'am.
Teresa Jackson.
Ms. Jackson, you're the mother of Mr. Latine?
Yes.
Thank you for coming to court today. Appreciate it. Are you from Broward County?
No, I'm from Dade.
How was your drive up here?
We left early enough to get here on time.
That's okay. Heavy traffic?
Yeah.
You had to go through Golden Glades interchange, probably.
No, I went Turnpike to I-75 to 595 to I-95.
There you go. All right, who'd you bring with you?
One of his best friends and his father.
Okay. Thanks for coming to court today. I appreciate you coming in. Let me just ask a couple questions. Ma'am, did you have contact with the alleged victim?
No, sir.
No, I'm not. I'm talking. There's somebody in court I'm speaking to. Go ahead, ma'am. See, do you have any comment about an appropriate bond in this matter?
Your Honor, I spoke with Mr. Jellin this morning. No, there's no contact, Your Honor. I certainly understand the mitigation for having no priors or just possession of marijuana prior in his family ties. However, based on the level of violence, I told him what I believe an appropriate bond would be $10,000 on one, $2,500 on two.
Okay. No contact. Anything you want to say about bond or release conditions at this time?
Judge, again, it's not a wealthy family. Does not have significant priors. It mentions possibly a fracture or dislocation. We know oftentimes, again, I'm not saying any of this is good, but oftentimes it's hard to tell with those types of issues till a little time goes by. Having been an athlete yourself, you know that.
Well, that's I'm not sure a good one, but I guess. Now let me ask you this, ma'am. Are you employed at this time?
Yes.
What type of work do you do?
I work for Department of Justice.
You do? All right.
Not a high-paid individual, but she does work for the government.
Okay. All right. How long have you been with the Department of Justice?
35 years.
How long?
35 years.
35 years. And you haven't retired yet? Are you going to retire soon?
I have another son, so no.
Okay. All right.
And Judge, again, the significance of the employment is that not that anybody would be treated any differently for that, but obviously they understand the significance of the charges, of the authority of the court in turning up to court, which is what bond is for. So we're just asking for a low financial bond, low monetary bond.
Court's going to set the bond on count 1 at $8,500, count 2 at $1,500. So the total bond's going to be $10,000. I'm going to go below the state, but I do take into consideration Mr. Jellin's arguments today. Bond's $10,000. The court will, and it's also based on the level of violence. I'm going to order that Mr. Latine have no contact directly or indirectly with the alleged victim. That's Jennifer Edwards. Don't call her, don't text her, don't email her. Stay 500 feet from her at all times. That's where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're on release. Mr. Jellin, is there anything else we need to cover?
That's it, Judge. Rashad, call me when you get out. You're going to get a court date because the case is filed. That's the problem here. Is it not in custody? Just call me when you get out, all right?
Let me just say, the first number in my mind was a little bit higher than what Mr. Jellin was the statement went, but Mr. Jellin's argument and his presentation was very helpful to your son today, all right, ma'am?
All right, thank you.
So I want to thank you, and I want to thank your friends and family for coming to court today.
All right,
I wish
thank
you
you.
a safe trip back to Miami, all right?
All right, you as well. Have
Thank
a
you,
blessed
Judge.
day.
And thank you, Mr. Linder.
Okay. Now, Mr.
Good morning. Michael Weinstein. I represent Omar Wofford. He was on the extradition docket. He had a notice for 9. And the state's telling me that those are set for 8:15.
Okay. Well, Omar Wofford did make it to court this morning.
Okay.
That was the one prisoner they weren't able to bring to court.
Okay.
And what I did was, I believe I signed a 60-day extension in absentia for him.
Okay.
And I didn't know you were on the case. The public defender was
Yeah, no, we filed our appearance a couple days ago.
Well, the public defender was there on the case.
No, he was not represented by the PD. I don't think that's on the docket. I think the only attorney of record is me. So, regardless, I understand.
All I know is that there's a public defender there, and I didn't look in the computer.
I understand, Judge. I understand.
But, so what I did was I reset the matter for Monday,
Okay.
8:15, and then, let me see something else. There was one other twist with it.
Mr. Edwards.
So he wasn't even brought over?
He was not even brought over.
Okay. All right.
You know what I would do? I would contact Mr.
Farnsworth?
Farnsworth about it. He knows more about this, what's going on behind the scenes than I do over there.
Thank you, Judge. I
All right?
appreciate it. All right.
If I would have known you were the attorney on the
No,
case,
you would have waited. I understand.
I would have waited. I would have put it off.
I know.
Okay?
Yeah, no, his notice was pretty clear. It said 9 o'clock. So, all right. Thank you, Judge.
Yes, sir. Thank you.
And so I just hope we could take care of just one matter with 3 co-defendants real quick. Brigida Daniels, Rodney Hilliard, and
Do you own any property, bank accounts, automobiles, trucks, bonds, money, circle these notes, and these notes, and heart. Circle the notes individually, press and heart.
Okay, so
you asked me, but you know you don't look.
who are they?
Brigida Daniels.
Okay, so Gilliard and Shelton are 2 of them, right?
Yes, and they're towards the back.
And is Daniels a female?
Yes. Yes.
What are you ready to do most? Put a 0.
Where's she? Toward the front?
Could be, yes.
Date of birth.
Judge, Brigida Daniels' attorney called me this morning.
Line frame for the city schedule.
Who are the other 2, please?
Gilliard and Shelton. Towards the back.
Page 25. Thank you. Page 25. Judge Monique Brochu is Mr. Gilliard's attorney, and Patricia Jones is Mr. Shelton's attorney. I have their phone numbers if the court would like them.
Patrick Jones, Your Honor, if I could, well, I'll wait till Your Honor gets the paperwork and they're up.
I've got Brigida Daniels, Rodney Gilliard, and Walter Shelton.
Okay, I guess we just need them.
So, you want to give me the telephone numbers of the attorneys?
Well,
Sure. For Gilliard, Judge, it's Monique, Brochu. Phone number's 954-713-2724. Walter Shelton's attorney is Patricia Jones. Patrick Jones, 954-779-1994. Miss, is it Daniels?
yes.
Her attorney is Tamara Curtis, and Ms. Curtis is actually on her way over to Conti facility right now.
And, Your Honor, what I can advise the court is the reason that these 3 co-defendants are before you is the state refiled all their informations to have them all on one information as co-defendants. Every single one of them has been arraigned by their respective judges.
Okay.
And they've all been on the no bond offenses. They've all been ordered to be held no bond previously.
You have children?
I have no objection. I can advise the court on the bondable offenses, what the bonds were previously set at. And now they're all going to be going for, I think, on Monday next week before Judge Bidwell. The cases have all been reassigned to Rock Court.
Let's go with Daniels, count 4 and 5. What were
Count 4, Richard. Well, the kidnapping she was ordered held no bond by Judge Robinson over the weekend, and he also arraigned her on July 7th.
Okay. Let's count 5.
Count 5 was originally set at $50,000.
Okay.
On Gilliard, the kidnapping was ordered to be held no bond previously. The sexual battery, it's actually an armed sexual battery. He was ordered to be held no bond.
Got it.
And he was, just for record purposes, he was arraigned before Judge McCarthy on July 1st.
Okay, what about
Walter Shelton, the kidnapping, he was ordered to be held no bond. And the 2 sexual batteries, the bonds were set at $100,000 each. And he was arraigned by Judge Contini on July 1st.
Okay, so let me ask Mr. Miller, is Tamara Curtis assistant public defender?
Yes, Your Honor.
So do you see any problem with me just on 4 and 5 letting it stay at no bond on 4 and count 5, $50,000? Or do you think?
Judge, I have no problem with
Okay.
that this time.
So we're
We can
gonna
take
do
it up
that.
with the division judge.
We're going to do that, and on Rodney Gilliard, we're going to go ahead and 5 and 6. They're both going to be no bond. I know Ms. Bush was probably on top of that. And then Walter Shelton, count 6, no bond. 7, 100,000. 8, 100,000. There you go. Okay, now. Okay, so we've gotten that far. Anything else? No.
Not on these.
Okay, now, let me just introduce myself. My name's John Hurley. I'm your judge this morning. We are in first appearance court. Today is the day the court determines whether or not there is probable cause for your arrest. We're not here for trial. We're not here to determine whether you're guilty or not guilty. That is not for today. I'm telling you that because when you get called forward, you do not need to tell us about your case. You don't need to explain yourself, defend yourself. You don't need to make any excuses. Those things are not for today. Save those for your attorney in a private meeting. Understand that everything today is being recorded. You have the right to remain silent. You should utilize that right at all times. But if you give up the right to remain silent today, whatever you say can and will be used against you. Also, if you have a private attorney, when you're called up, let me know who that is. We'll contact your attorney and let them know that you're in court. Deputy, may I help you with something?
I'm here for Defendant Fillmore.
Marcel Fillmore, Your Honor. It's a perfection.
Marcel Fillmore.
Yes, Your Honor. I've provided, Your Honor, and defense supplement report, but I also, this is Detective Toledo, and I asked Detective Toledo to appear just to clarify any issues or facts that the court may
Okay, so will you raise your right hand?
concerned about.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Okay, put your hand out. Tell us your name.
Detective Marcos Ruiz Toledo.
Okay, and you're employed by
The Broward Sheriff's Office.
Sheriff's Office. And did you have an opportunity to investigate Mr. Marcel Fillmore regarding the robbery, the burglary, and possession of a weapon or ammunition by convicted felon?
Yes, Your Honor.
Okay. The issue here was, what was the issue?
Your Honor, well, two things. One, there was an issue with identification. Two, I think in order for this, Your Honor, I'm going to be seeking to foreclose on the burglary with battery, and I believe more facts should be brought to the court's attention to reach that level. Also, I want to clarify for the court right now, on count 1, we're seeking probable cause for attempted robbery with a weapon. In this instance, just to clarify before we get into the alleged facts, because I know there was mention of a firearm. Your Honor, for the purposes of this charge, the state is alleging that the rock and the manner it was used was a weapon.
Okay, let me just review this real
Sure.
quick.
What county?
Can you get him to tell me what happened to me? Hey! Clarify what you're talking about.
Yeah.
Okay, so here's the issue that you say that it was an attempted robbery. Okay, so I see that part.
Yes, Your Honor.
For probable cause. The burglary with the assault or battery. We have a young man allegedly breaking the window of a vehicle after he allegedly says, give me all of your, I'm not going to say it, but give me all your belongings. And then he allegedly picks up a rock, breaks a window, and says he reaches in the vehicle. But after that, the court doesn't see anyone in fear. The court doesn't see anyone who's been battered. Would you agree up to that point from what we see here? That's missing.
No, Your Honor, that's why I've asked Detective Toledo to be
But
present.
on the document we have, that's not there.
It would appear, Your Honor, and that's why, after speaking with Detective Toledo yesterday, I asked him to come in.
Okay, so, the detective's under oath. Would you like to, if you want
Yes.
to go ahead and ask questions, go ahead.
Detective Toledo, you had an opportunity to investigate this case.
Yes, sir.
And you took a sworn statement from the alleged victim, Thomas White.
Yes, sir.
Could you please tell the court, based on your investigation and the sworn statement you took from Thomas White, starting from the beginning, what the what allegations were made against Mr. Fillmore regarding this incident?
Okay, Mr. Fillmore ran up to the driver's side door of Mr. White's vehicle, asked him to give him all his stuff. At that time, he was producing what Mr. White believed to be a weapon from behind his lower back.
Now, what time, this was, it looks like 13:47, correct?
Yes, sir.
So that's 1:45 in civilian time, right?
Yes, sir.
1:47, I'm sorry. Okay, so go ahead and,
So, simultaneously, the victim, Mr. White, started to open his door in order to strike the suspect, Mr. Fillmore. At that same time, Mr. Fillmore produced a large rock with his right hand, which he smashed through the window of Mr. White's vehicle, maintaining grip on the rock. Mr. White put up his hand. The rock actually struck Mr. White's hand, causing small lacerations, and the broken glass cutting the top of his forehead.
the broken glass cut the occupant of the vehicle's forehead.
Yes, sir.
Okay.
At which time
Did you see that cut?
I saw small lacerations, but it was already cleaned up. The blood was already cleaned up by rescue.
Okay, but you showed up on the scene.
I showed up after the fact at the
Right,
station.
But you showed up on this. Were you there on the scene when this allegedly occurred?
No.
Where it occurred?
No,
You saw the alleged victim where at the station?
at the station
Got it.
already.
Okay.
At which time, after the rock had already entered the vehicle compartment, Mr. White says that Mr. Fillmore tried to grab for whatever he could before he left, fleeing.
When you say grabbed for whatever he could, what do you mean by
He's,
that?
I presume he just started grabbing around, see if he could take anything from within the vehicle.
Okay.
Now, this statement was corroborated by an individual who was parked right in front of Mr. White on the street, a witness.
Did you get the name of that person?
Yes.
Is that Yanovac?
Yanovac.
Yanovac.
Yes, sir.
Okay, what did Yanovac, did you speak with Yanovac?
I've not spoken with Yanovac yet. I haven't been able to get a hold of him, but Deputy Batista, who is the original report writer, did speak to him.
Okay. And, okay. So, you want to continue, sir?
Your Honor, if I could just very briefly, Detective Toledo, when you took the witness's statement, when he said he was struck and the glass struck him, was he still sitting in the vehicle when that occurred?
Yes, he was all the time inside the vehicle.
Okay, thank you. Please continue.
After that incident, Mr. Fillmore met up with a second individual who hasn't been charged yet, but it's believed that Mr. Fillmore was going to trade drugs for a gun. They were spooked by the police as they were looking for Mr. Fillmore. The second individual dropped the gun, and Mr. Fillmore picked it up and started running.
Well, let me ask you this, how do you know that? How do you know that Mr. Fillmore picked up a gun?
We know from several witnesses at the park that saw Mr. Fillmore running with a gun, and Sergeant Anderson actually observed Mr. Fillmore with a gun running as they were chasing him.
Okay, how long after this incident at the vehicle with the smashing of the window was it that somebody saw Mr. Fillmore with a gun?
Judge, at this time I'm objecting to this line of questioning. It seems that this is a second incident that is not related to the issue at hand before the court, and we're still at the PC phase.
This relates to, he's also been charged with possession of a firearm or weapon by a
Yes.
convicted felon.
Right.
Yes.
So that's what I'm trying to get at, figure out if he really had this weapon. So keep going. Now let me ask you this. So what was the time frame between the rock hitting the window and someone seeing him with the gun?
Approximately 20 minutes or so.
20 minutes, okay. All right, and let me just back up. Did anybody see him with a gun or a firearm at the time he smashed the window?
No.
Okay. The person in the car felt that he may have a gun because he reached behind his back, but nobody saw a gun.
Correct.
So 20 minutes later, some people in a park, do you have their names?
I believe Deputy Batista still has those names.
Okay. They saw him pick up a gun, and the gun was dropped by some other local person?
Yes, sir.
Okay. All right. And go ahead, sir.
So after they chased Mr. Fillmore, that same gun was located right in the vicinity of where Mr. Fillmore was, underneath a shed.
Okay. How do you know it was the same gun?
We're supposing it's the same gun. It was just similar to what he was carrying, according to Sergeant Anderson, who actually saw the gun in his hand as he was running.
Sergeant Anderson saw the gun in his hand as he was running?
Yes, sir.
From the time, if you know, from the time Sergeant Anderson saw him with the gun to the time the defendant was apprehended, do you know how long that time was?
It was approximately a minute to 2 minutes away.
Okay. And were you there, or did you go to the location where the defendant was apprehended?
No, I maintained my status at the station after the fact.
I understand. I'm just trying to clarify the issues, that's all.
No.
What I'm trying to figure out is where he was apprehended, from where he was apprehended to where this handgun was located. I mean, is it a closed area? How far away would it have been?
I'm not able to answer any of those right now.
Okay, were you able to pull any prints off the gun?
We have DNA from the weapon and DNA from Mr. Fillmore, who volunteered DNA, and we sent that to the lab already.
But to back up, one of your detectives saw this defendant running with a handgun?
Yes.
Okay, and he was apprehended, and when he was apprehended, they found a handgun within a close proximity of him?
Yes, Your Honor.
And it was similar, that you're saying that this detective said it was similar to the handgun he saw him running away?
Yes, Your Honor.
Okay. All right. Do you know whether or not this defendant knew the man in the car? Did they know each other?
Not the individual in the vehicle, no.
Okay. Was the window of the vehicle... Here's something I want to find out. At one point... Stop, he was on the Here's what I need to find out here. It says, while White's vehicle was stopped, he was on the telephone. I'm reading from the report, the supplemental report, third paragraph down. While White's vehicle, do you see that?
Yes, sir.
He was on the telephone. He hears this defendant say a racial comment to him. Give me all your SH cracker. Now, was the window up or was the window down?
The window was partially down, not completely down.
Okay. All right. Was and Mr. White was he able to identify this?
Yes, a show-up was conducted after he was apprehended, and from what I'm told, he positively ID'd him right away, no hesitation.
Was there, did you look at the vehicle, Mr. White's vehicle?
It was not on scene when I arrived.
Okay. All right, I don't think, go ahead, Steve.
Well, Your Honor, if I may, and if the court wishes to take judicial notice, I checked on Google Maps the distance between where the gun was allegedly found at 111 Northwest 8th Avenue and where he was, according to the report, arrested at 111 Northwest 6th Avenue. Okay. And it's showing that the distance is approximately 1/10 of a mile.
Okay. All right. Anything else, Dave?
Detective, did you have an opportunity to ask Mr. White when, at the moment where Mr. Fillmore was allegedly striking the window with the rock in his hand, was Mr. White in fear?
Yes, he was.
And at that time, did he have an opportunity to observe that Mr. Fillmore had something in his hand?
Yes.
No further questions, Your Honor.
Okay. Mr.
Can I
Miller,
ask a few, Judge?
I'll give you a couple questions. I'll let the defense, this is a very serious case, I let them ask them a question. Go ahead.
I'll be nice, Judge. Real quick, how do you know he was in fear?
He told me so in the state statement.
Okay. Now, you said that you assumed that he reached in and grabbed a whole bunch of property. Where are you getting that assumption from?
No, I did not assume. I said that he reached in and started grabbing as per the victim's statement.
Okay, I wrote down that you said, I assume he reached in and started grabbing stuff.
You must have misheard. We'll keep going.
I'm sorry, you said we'll keep going?
Sure, go ahead. Next question.
Okay. The second incident, the alleged handgun, how far away was the police officer when he said he saw a handgun in my client's hand? Stand up straight.
I was not on scene. I really couldn't tell you. All I got is from the report where he actually saw him running with the handgun.
Okay, so something that looked like a handgun. You can't be sure it was a handgun, correct?
He told me it was a handgun. I would assume that he knows what a handgun would look like. I'm going on his testimony to me.
Okay, but you don't know.
I was not there.
Okay. No one ever saw him. No, but when he was apprehended, he did not have a handgun in his possession. Is that correct?
Not on him at the time, no.
Okay. Now, earlier you testified that the victim, the alleged victim in this case, opened the door into Mr. Fillmore. Is that correct?
Yes.
And that's when he broke the window with his rock. Is that correct?
It was a simultaneous action between the two.
Okay, so the door was actually open when the window was broken. Is that correct?
Correct.
Please stop.
And I threw the rock and ran.
Okay, I'm done.
Sorry,
Thank you.
sir. Please, very sorry.
So, I think for the record, you said I threw a rock.
No, that's not what he said, Judge. He said he tried to hit me with the door.
Yeah, I'm listening. Can you tell the judge
Stop for a
something?
second. We're going to take about a 2-minute break. I'll be right back. State, are you seeking a foreclosed bond or release conditions on count 2?
Yes, Your Honor.
Today, the court will find...
Judge, I'm
Go ahead,
sorry, may I make my argument?
Yes, sir, go ahead.
Just briefly, on count 2, it appears that that door was open when the alleged battery occurred. He was not inside the car when it happened. I would argue that that's not a burglary. It's criminal mischief. I would have to stop. Judge, there's no proof evident, presumption great. Remember, we got that high standard to reach here, and with that door being open when that window was allegedly smashed, you've got a question of fact whether or not this was actually a burglary. And so I'm asking the court to find no proof evident, presumption great, and give him an appropriate bond in this case.
Okay. Well, the court finds whether the door was in the process of being opened or whether the door was completely closed. The court's understanding of the facts in this case was the defendant was in contemporaneously attempting to smash the window of that door. And in any event, whether the door was completely open or completely shut, the defendant, in this court's opinion of reviewing these facts, broke the plane of where that door frame was, whether it was a closed door or an open door, and went into the vehicle with the rock, glass particles hitting the defendant or hitting the alleged victim in the face, the rock hitting the alleged victim's hand. The court believes that that is the battery, that is the burglary, and the court will...
Judge, I'm sorry, can I throw out a hypothetical real quick?
I'm sorry?
Briefly, sir, briefly.
Okay, so standing at the front door of your house, you open the door, okay, outside of the house. I didn't enter the plane. Everything happens on the threshold there, outside of the house. Are you still going to have a burglary, or is there something else going on here? Do you have proof evident, presumption great, or is there something that still has to be decided by a finder of fact?
No, in this case, the court believes that this alleged victim was still in his vehicle, and no matter where the door was, this defendant allegedly caused a rock and glass to enter the compartment of that vehicle and strike the alleged victim. And the court also notes that these acts were preceded immediately by a racial comment, which I assume, did you meet the alleged victim?
Yes, sir.
What ethnic group would he be a member of? A white man?
White male.
White male. So he's a white male, and this defendant allegedly, just prior to this crime, referred to him as a cracker. So that gives the court the court believes that there was the intent to cause harm to him at this stage by his own words. The court also notes that his own words today put him at the scene of the crime. He allegedly said he opened the door and I hit the window with a rock. So the defendant's own words in court here put him at the scene of the crime with a rock in his hand and smashing the window. After that, we can rely on the testimony of the alleged victim. So count 2, proof evident, presumption great, defendant will be held without bond pursuant to the Preston case and the Keel case. This court believes it has no discretion to set a bond today, and that the defendant's only manner of relief is to have an Arthur hearing in the trial court. Now, State, is he a convicted felon?
He's an adjudicated delinquent if the court would like to go sidebar. You know what, and for the bond that the court's going to have to set on count 1, the court should probably be aware of his juvenile record also.
You want to go to the telephone and we'll tell you what the juvenile record is, Mr. Miller? Okay. Okay, court will consider his juvenile record. Count 3 and 4, the court's going to find probable cause. Count 1 is an attempted robbery. Now, State, do you have any, let me ask defense, sir, you want to state do you have any comments before the court sets bond on count 1, 3, and 4?
Judge, no, I do not. If you want to ask, that's fine with me.
Sir, do you have any money in the bank, Mr. Fillmore?
Yes, sir. If I have a bond, I have my family come up with something and get me out.
How much money do you have in the bank?
Probably like $1,000.
Do you own any land or property here in South Florida?
No, sir.
Okay. Sir, I'm going to, based on your serious juvenile record, the facts, alleged facts of this case, that you not only tried to attack a man or attacked a man and his vehicle, referred to him in a racial manner, then allegedly ran away, picked up a handgun, witnesses saw you with the handgun, and taken into consideration your very serious juvenile record, the court believes you represent a danger to the community. The court also notes that you with your juvenile record, you shouldn't have a handgun in your possession. And the court notes the strength of the case. There's several witnesses who saw you during the course of these criminal acts. We have the man in the vehicle who claims you took the rock, the glass went in, he got hit, the detective saw the cut on his head. Then you in court today put yourself at the scene of the crime by your own words. You said you had a rock, you said you smashed a window. Now I know you have a different version of it, but you put yourself at the scene of the crime. The court believes you do represent a danger to the community. The court notes the strength of the case against you. Count 1, like I say, based on your juvenile record, the facts of the case, $50,000 on 1. Count 3 and 4, those will be $10,000 per count. And count 2, the burglary, you're going to be held without bond. The court will order. You have no contact with Thomas White directly and indirectly. Thank you. Thank you.
Thank you, Your Honor.
Now, may I see Virginia Drake?
North Broward, Judge.
North Broward.
Judge, will the court do a medical screen on her, just based on information I read in the probable cause affidavit?
Okay, Ms. Drake, ma'am, you were, I'll do that, I'll order that. Currently pregnant, allegedly grabbed him, I'm not gonna, private area. Is there, I find probable cause.
No priors.
Priors. Let me ask, ma'am, was there contact?
I didn't see a name for the victim.
Wasn't a name for the alleged victim?
Nothing.
Okay, ma'am, are you currently employed?
No,
Who's gonna bond you out of jail today?
my sister.
Do you have any money in the bank yourself?
No, $100.
That's it? Okay. All right, ma'am, I'm going to say you're bonded $1,000. It's difficult for me to say who to stay away from since they didn't list the name. But stay away from the man who you have a child with, or you're going to have a child with. All right, ma'am? Thank you.
Hey, Judge, how are you? Judge, at 1:30, I'm on a case called Dwayne McLean. Apparently the PD didn't know that I filed on it. I'm the lawyer. They set a motion at 1:30 that I want to delete because I'm working with Mr. Jones on the case filing aspect of it. So I just wanted to make clear I want to delete the 1:30 Dwayne McLean.
It's a 30-day?
Yeah.
Okay.
33.
Okay, I'm not going to be here in the afternoon. Could you remind?
I'll take care of it.
Okay.
Who's going to be here?
I think it's Tudor, Jack.
So can I have your JA handle?
Yeah, sure.
I'll take care of it.
May I see Deidre
Okay,
Key?
thank you, Judge.
That's fine.
All right.
May I see Deidre Keen?
Paul Ryan, probably, Your Honor.
Paul Ryan, Your Honor.
Ms. Keen, domestic battery, the court finds probable cause. Are there any priors on Ms. Keen?
No, Your Honor.
No? Okay, Ms. Keen. Victim resides located. Ms. Keen, how long have you lived down here in South Florida?
All my life,
Are you currently employed?
yes.
What type of work do you do, ma'am?
Pharmacy tech.
Okay. All right, ma'am. If I leave you out of jail, can you stay away from Mr. Dennis, Willie Dennis?
He's my stepdad. I'm in the process of moving, but I don't have the funds to.
Okay, but can you stay with a friend or somewhere else for the time being?
Yeah.
Okay, ma'am, did you have contact with Mr. Dean?
No, Your Honor.
Ma'am, I'm going to release you on your own recognizance today. but I'm going to order you have no contact with Willie Dennis. Stay 500 feet from where he lives, works, goes to school, and you're not allowed to possess any guns or weapons. If your clothing and your belongings are at that house, you're going to have your mother or someone else pick them up and take them to you. All right, ma'am?
Okay.
Thank you. Okay, may I see Keon Glanton?
Main jail.
All right. Mr. Glanton, you are charged with a domestic battery. The court finds probable cause. Advised your boyfriend struck her in the face and he fled on foot. Her boyfriend grabbed her around the throat with his bare hands, struck her on the mouth. Corroborated by a witness. Okay, go ahead. State, do you have any?
March of this year from Dave, resisting without violence. 2014, domestic violence battery and an aggravated battery. That was dropped. 2000.
Cheer.
Yes, Your Honor.
Okay, go ahead.
No, that was last year.
Last year. Go ahead.
Out of where?
Okay, anything else?
I'm just looking to see. They had other batteries, Your Honor. Out of date, they were dropped. 2011. Possession of cocaine, 2009. Resisting without violence, 2007. Possession of cocaine, drug paraphernalia, 2006. And the prior, Your Honor.
Okay. Mr. Miller, anything you'd like to say?
Yes, Judge. Mr. Glanton is a lifetime resident of Broward County. He has a job. He works at Total Mirrors. He's got 2 children he takes care of, 3-month-old and a 1-year-old. Strong family ties, no money or real estate. He does have a place to live separate from the alleged victim while this is pending. He's hoping that his family will help to bond him out.
Okay, sir.
Your Honor?
Yes, sir. Go
We
ahead.
can tell you at least one of the batteries, because we see there's evidence of a no contact order. At least one of the batteries that a date was against the same alleged victim.
Okay, sir, I'm going to set your bond at $5,000 today based on your criminal record, the facts of the case. Or do you have no contact with Makisha McLean? Do not call her, do not text her, do not email her. Stay 500 feet from her at all times. And also, Aquarius Williams, no contact with him directly and indirectly. Thank you.
Yeah, I want to keep it.
Okay. Daxon Georges.
Judge, may I just briefly mention something about the probable cause?
Decline, PD. Mr. Officer.
So you're charged with domestic battery. The court finds probable cause. Are there any priors on this gentleman?
One moment, Judge.
Ma'am, did you have contact with the alleged victim?
Okay, you didn't give me too many.
9:23 in the morning. Literally pushed her backwards onto a couch, struck her with a closed fist, unknown number of times in the face. She had both of her eyes swollen, red, injury occurred. Okay. Sir, are you currently employed?
Yes, I'm a cab driver.
Okay, do you have money in the bank?
I got some money in the bank.
Okay, how much do you have, do you know?
Maybe 1,200.
Okay. How long have you lived in South Florida?
Over 15 years.
Go ahead, state their priors.
No, Your Honor.
15 years.
I understand, sir. I'm gonna, let me see here.
Your bond is $75,000. Can you afford
So I'm
it?
going to set your bond today at $6,500 based on the level of violence and the
Yes,
court's
sir.
concern for the safety of the alleged victim. No contact with Constant Dumas. Constant, do not call her, do not text her, do not email her. Stay 500 feet
Okay.
from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're out on release. Thank you.
All right, good luck. What was the bond?
It's like I heard you.
What was that bond, Judge?
$6,500.
Thank you, Judge.
Sure. I see Alexandra Babkin.
She's at North Broward.
Domestic battery by strangulation. The court finds probable cause. Do we have any?
Yes, Your Honor. I just need one moment to check.
Judge, mental health screen.
Okay.
You see this? Did you talk to the victim in this case? Yeah. Did you? Yeah. I'm just, Your Honor, he has multiple cases. I'm just checking to see who the victims were in those cases. Okay, Your Honor. He just pled out an assault on a law enforcement officer and trespass April 1st of this year. Last year, he was convicted.
When was the arrest on that? What was the case, like a 14 or 15?
No, it's a 2015 case. It looks like he pled out at magistrates.
Assault on a Leo and what else?
Trespass.
Got it.
He also, last year, convicted of violation of a domestic violence injunction and violation of a no contact order. That was against all these cases are against a different alleged victim or different victim. Also 2014, violation of injunction and resisting without violence. He violated probation in that case. He was arrested last year for battery against the victim and that was dropped.
It was DV?
Yes. Also in 2014, DUI property damage, leaving the scene of an accident.
Photo order, Judge.
Got it.
Did you have anything else? I told the judge that.
New York?
Oh, no. He also had a previous DUI out of New York.
What year was that? Do we know?
We're checking.
2011. And 2013, it looks like. The same one.
I think it's the same thing, so 2011.
All right. What do you do for work right now, Mr. Babkin?
Thank you, Keeper.
Used car dealer, my own company.
Do you have any money in the bank?
Yes,
How much do you think you have in the bank?
like 1,500 maybe.
Okay. Do you have, do you own land or property here in South Florida?
No,
Do you have family down here?
my wife,
John
You in the military at any time, sir?
I'll give you a copy of the warrant, and I'm going to keep it.
not in America.
Okay. So I have here that you were under the influence of alcohol and you attacked your girlfriend unprovoked, grabbed her by the neck, allegedly saying, "I will kill you." She said that she lost the ability to breathe. She had red marks on her neck and her shirt was slightly torn. Okay. I do note, sir, this year, assault on a police officer, trespassing. Last year, 2 violations of injunctions, violation of a no contact order. Last year, arrest for domestic battery on another woman, DUI, leaving the scene of an accident in New York, a DUI in 2011. So there's alcohol issues in the past, domestic issues in the past, injunctions in the past, and I'm going to order, ma'am, I'm going to give it to you with a monitor based on the alleged threats to kill, the level of violence. What's going to set your bond today, sir, at $40,000, pretrial release, GPS monitor, waive the cost of the monitor. The court will order, sir, you have no contact directly, indirectly with Charlene Thomas. Do not call her, text her, or email her. Stay 500 feet from her at all times. That is where she lives, works, goes to school, anywhere in between. You're not allowed to possess any guns, any weapons, any firearms while you're out on release, and you are not allowed to consume any alcoholic beverages. Thank you, sir.
You're welcome.
Now see, Ivan Vedrine.
Main jail. Judge?
Yes, sir.
Mr. Vedrine has indicated an intent to hire private counsel. He's not sure yet. I'd ask the court to reset this to tomorrow afternoon to give him an opportunity to secure an attorney.
Sure. Okay, I'm going to, in the meantime, I want to just say that the defendant's not allowed to have any contact with Haley Garcia, directly or indirectly. No contact with Haley Garcia, no contact directly or indirectly with Laren. I saw the name here just a moment ago. There was another person in the house at the time. Laren Emile. No contact with Laren Emile directly or indirectly. Reset Friday p.m. Thank you. Okay. Now, what about Ashley Archibald? Ashley's a domestic violence case that was put in down the line a little bit here. Ms. Archibald, you're charged with battery on a person 65 years of age or older. This is a domestic violence case, though it was not in a stack of domestic violence. The court's going to find probable cause. Excuse me?
All right.
Go ahead, state any priors.
Gotta find the paperwork, Judge.
Allegedly, do you have anything to add on Ms. Archibald, sir?
Sure, Judge. She's been here for about a year at the same address, been working at Five Guys for the entire time. Two children that she takes care of. They're currently with her mother. Those children are 2 years old and 7 months old. Strong family ties, no money or real estate, does have a place to stay separate from the alleged victim, and is hoping that her family will bond her out.
How about that? I just need one moment, Your Honor.
It's alleged that she got in an argument with her grandmother and hit her grandmother on the head with a cell phone and then kicked her in the stomach. However, her grandmother then got a hold of a hammer and allegedly hit this defendant on her leg in self-defense. We need a medical screen on this, Mr. Miller. How's your leg, ma'am? No? Okay, go ahead.
Your Honor, she is, let's see. She's on probation with Judge Cohen for, she pled out felony battery to 2 counts of misdemeanor battery against the same alleged victim. Placed on a year's probation, January 23rd of this year.
Okay. What's the case number?
14-6060 CF10A.
Okay. That's a 948 issue, right?
Yes.
948. All right, ma'am. Today the court is going to set your bond at $15,000 based on the level of violence and the fact you've already gone to court and you're on probation for allegedly abusing your grandmother in the past. I'm going to order no contact with Pauline Archibald. Do not call her, text her, or email her. Stay 500 feet from her at all times. You're not allowed to possess guns or weapons. If you eventually make bond, I'm going to order pursuant to Florida Statute 948 that you be held on 14-6060 CF10. Thank you, ma'am. Now, when I call out your name, please line up. Line up when I call out your name. We can move rather quickly. The following people have warrants for their arrest.
Hey, it's Eric Winder.
Now, let's see, Antonio Barnes.
Could you pass a message along to her when she gets back?
Sir, violating probation, no bond. Thank you. Julie Lampley, Patricia Gaviria, Edna Bird, Dorian Osceola.
Lampley is at North Broward.
Where's Julie Lampley?
North Broward, Judge. North Broward, Your Honor.
Thank you. Ms. Lampley, you have a municipal ordinance case. That is, hold on one moment.
No, I don't know. The case number that she's on probation for is...
I'll see you at 1:30 today, ma'am. Okay?
Okay.
Thank you, ma'am.
Thank you.
Yeah. All right. You're welcome.
How about Patricia Gaviria? Thank you.
Main jail.
Gaviria, you have 2 warrants, misdemeanors, 500 per count. Thank you. How about Edna Bird?
Could you...
Edna Bird. Miss Bird, no driver's license. Oh, I'm sorry, I'm picturing the wrong stack, Miss Bird. Give me a moment.
Can we resolve this, Judge?
Let me look here real quick. Miss Bird, no driver's license, ID card, and the ID card is... Ma'am, I'm going to let you bond out $25. Thank you, ma'am. Okay, what about Dorian Osceola?
Joe.
Miss Osceola?
Osceola is president of the Maine, has declined PT.
Violation of probation, 3 counts, no bond. Thank you.
Good luck.
Missy Siobhan Duggins, Jacqueline Ramos, Barbara Jackson, okay, Siobhan Duggins.
Judge, Ms. Duggins wants to know if the court can resolve counts 3 and 4. She's going to see her judge on Monday on the felonies.
Hold on one
These
second.
misdemeanors are from 1993.
No, you know what? I'm not going to do that. One's a theft, and I
Okay.
don't know if there's restitution. So, ma'am, count 1 and 2, no bond. 3 and 4 are 1,100. Ma'am, remind your felony judge he or she can resolve these cases in their courtroom. You don't have to go back to the division judge. Thank you.
They could just do it all together?
They can do it all together. They're allowed to do it now. All right, Jacqueline Ramos. Ms. Ramos, you have a misdemeanor, $500 on count 1, count 2, out of county hold, no bond. Thank you. How about Barbara Jackson? Barbara Jackson, ma'am. A felony warrant on count 1, no bond. Count 2, a misdemeanor on count 2 is 1,000. Thank you, ma'am. Okay, Alex Medina, line up. Kevin Caruso, line up. Lloyd Bellamy, Kevin Rogel, Nathan Davis.
You want Caruso?
You speak English or no? Medina's North.
Sir, count 5 is a warrant, $500 on a misdemeanor for theft. Thank you. How about
This is Mr. Caruso.
Kevin Caruso? We'll see you at 1:30 today, sir. Thank you.
Yeah.
How about Lloyd Bellamy?
North Broward.
Mr. Bellamy, we'll see you at 1:30 today. Thank you. How about Kevin Rogel?
Main jail.
Sir, you have a misdemeanor, $500. That's a warrant. Thank you. How about Nathan
Right.
Davis?
Off you go. North Broward.
Mr. Davis? Is that him right there? That's Davis? Do you have a traffic?
Not Nathan Davis.
It's not.
It is Nathan Davis.
Yeah, there you go.
I don't know how. It says North
$2,000, sir.
Broward on my docket.
$2,000.
Can he resolve this? No. 2011.
No, we'll let it, hold
8
on.
days.
Wait. Give me a moment. Give me a moment.
All right, hang on.
Give me a
Just gonna
moment.
look and see if
Give me a moment. Just let me look here. Nathan, do you still live on 151st Street in Opelika?
Yes, Judge.
Okay, so I'm going to release you on your own recognizance, all right?
Nice. All right, good luck. Take care of it. Thank you, Judge.
Yep. He actually didn't have a bad driving. It was just one thing from the past that stuck him, all right? Tevin Pinnock, Joshua Lapidus, Stephen Edwards, Urbano Cabrera Alejo. All right, Tevin Pinnock. Sir, a warrant, 5,000. Thank you. How about Joshua Lapidus?
Lapidus has private counsel Jim Lewis. Mr. Lewis, know you're here?
I don't know.
We don't know if he knows he's here. We don't have a phone number.
Hold on.
I have a phone number.
Oh, you do have a phone number?
What's the phone number?
We do have a
Remind
phone
you when I come up.
What's the number?
954-907-2788.
There you go.
Yeah.
I left a message, sir. Thank you. How about Stephen Edwards? Sir, violating probation? No bond. Thank you. Urbano, Cabrera, Alejo, Richard Wagner, Malachi James, Michael Savage.
Mr. Cabrera needs a Spanish interpreter, please.
Dígale que yo no pude venir porque I in cama de copo. I have an accident. I have my bone broken. I need to stay in the hospital, not here.
Okay. All right,
Richard Wagner. So violating probation, no bond. Malachi James. Violation of probation, no bond.
North Broward, Judge. North Broward. All right.
I'm done. Violation of probation, no bond, Malachi James. Thank you. Michael Savage.
Kevin Kulik is his attorney. Does he know you're here? He knows he's here.
Okay, violation of probation, no bond.
Eddie?
All right.
What?
Eddie,
No.
Flatus Pena, Levon
North
Cruz,
Broward.
Jason Kaplinger, and Timothy Wise. All right, where is Eddie Flitas Pena?
North Broward.
Your Honor, he's going to need a Spanish interpreter.
Okay. Siete say, por favor. Yeah, what about Levon Cruz?
Change him. Right here.
Violation of probation, no bond. How about Jason
Good luck.
Kaplinger? Parole violation, no bond. Thank you. How about Timothy Wise?
Main jail, Timothy Wise, wake him up. Timothy Wise, please wake up. One moment, Judge.
Okay. How about Timothy Wise?
We got him, Judge.
Mr. Wise, you're here, no bond on a violation of probation. Thank you.
All right, you can go now. Go down that way and out that door, okay?
Marlon Fabius.
Go down that way. Down that way. Out
Marlon
that door.
Fabius. Marlon Fabius.
I should get hazardous duty pay, Judge.
Well, we're working on that.
Your Honor. Mr. Fabius, you might remember you had his co-defendant earlier this week, your private attorney here. This is just an add charge because we added you already found proof of evidence presumption grade for robbery firearm. We added a second count for the second victim. I showed you the paperwork earlier this week. Mr. Fabius is a co-defendant.
Judge Andrew Rear is Mr. Fabius' attorney. I did let him know that Mr. Fabius was going to be here this morning. I have his phone number if you want it.
Okay, go ahead. What is it?
305
Okay.
899 1212.
What's his name?
Andrew Rear, R-I-E-R.
Yeah, may I speak with Andrew Rear, please? Yeah, will you please tell him that this is Judge Hurley from Broward County? Okay, he's got a client named Marlon Fabius, F-A-B-I-U-S.
Okay.
His client has an additional charge this morning for robbery with a firearm. and I'm just letting you know that the state attorney's office has added an extra charge on him. Now, also, ma'am, will you please tell the attorney that the defendant has a hearing on July 14th, 2015.
Arraignment.
Okay. That's his arraignment. July 14th, 2015 at 8:45 in the morning.
Judge Merrigan.
I'm not, you know who the judge
Judge Merrigan.
Judge Merrigan, Merrigan. Okay. 8:45 in the morning. Okay. Judge Merrigan. All right. Okay. And you are Judge Hurley? Yes, ma'am. Okay. I will let the attorney know. Thank you. Okay. Sir, you're going to be held no bond. The court's going to find proof evident presumption great pursuant to the other findings on count 1 and 2. You're going to be held without bond on this charge also. Thank you. Okay. Now, may the court see John Williams, Carlton Brown, Michelle Hernandez, John Williams.
Judge, this is Mr. Williams. Mike Gottlieb is his attorney. Mr. Gottlieb is not aware that Mr. Williams is present in court. We do not have a phone number.
Okay, do you have Gottlieb's number?
I can get that, Judge.
Give me a moment. Sir, I advise your attorney, Mr. Gottlieb. He's aware. Thank you. Carlton Brown. Mr. Carlton Brown, step forward. Come on up, sir. Mr. Carlton Brown, possession of burglary tools, false ID given to the police, possession of a harmful new legend drug, possession with intent to sell PVP, also known as Flacca. Count 5, possession of alprazolam.
Have one favor.
Count 6, violating probation. That's a no bond hold. Count 7, paraphernalia. 8, resisting arrest without violence. 9, resisting arrest without violence. 10, license suspended. 11 and 12 are probation violations, no bond. So let me review. Count 1, 1,000, 2, 100, 3, 25, 4 and 5, 1,000. 6, no bond, violation of probation. 7 and 8, 100. 9 and 10, 100. 11 and 12, no bond. Thank you. How about Michelle Hernandez?
Judge, she's present at the main. This is a 2001 no valid DL. She has no ability to bond out.
I understand.
She's advising this is a not me case that's been in the works for some time. Wondering if the court can do something about this bond, perhaps a pretrial release or ROR.
Let me just take a look at it. Looking at her driving record. Okay, she has failure to pay traffic ticket 2014, 2015.
I just
license suspended 1, 2, 3. She has a DUI conviction in 2000. Okay, ma'am. Let me look here.
Susan B. Anthony.
It's not even on her driving record, actually. It's not on her driving record also, so. Ma'am, I'm going to, do you still live on Kimberly Boulevard?
Yes, I'm in a recovery center I'm at Susan B. right now. I've been there for 6 months.
Ma'am, I'm going to release you on your own recognizance today. However,
Thank you.
You're going to get notice to come back to court, and you're going to need to come back to court and address this. Even if you even if you say it's not, you're not the one that did this, you still should show up in court and address it with the judge. All right?
Okay. Thank you.
Thank you, Judge.
Shakayla Palmer, Alessandra Gaglio, Maura Sullivan, Jennifer St. Jean.
Ladies, come on out.
Palmer's North Broward, Judge.
Shakayla Palmer, please. Miss Palmer, where are you, ma'am?
North Broward.
Good morning.
Miss Palmer, you allegedly stole from Walmart on count 1. That's 100.
Yes.
Count 2, 3, and 4 are license suspended charges. Those are $500 and $500. Your total bond day is $1,100. Thank you, ma'am. How about Alessandra Gaglio? Where's Miss Gaglio?
Bonded, Judge.
Bonded? Okay, what about Maura Sullivan?
She's present at the main, Judge.
Yeah. Theft, grand theft, more than 10,000, less than 50. Count 1, count 2, 3, and 4 are false ownership of pawn items.
That's what she's
5, 6, 7, dealing in stolen property. Count 8, another grand theft. 10, 9, 10, 11 are dealing in stolen property. 12, 13, 14 are false ownership of pawn items. The court finds probable cause. Do we have any priors on Miss Maura Sullivan, also known as Maura Sowich?
One moment, Judge.
Do you have anything you want to add on this, defendant, sir?
Judge, she's a 20-year resident of South Florida. She's been in her current address for 5 years. She works as a private certified nursing assistant. She's been doing that for 15 years. She has an 18-year-old son she takes care of. Strong family ties, no money or real estate. The family's going to bond her out, Judge. We'll see if we can get some kind of relief over this bond. She's not going to be able to, her family's not going to be able to come up with this kind of cash.
Well, it says here the subject worked for the victim, Miss Ethel Bateman, who's 97 years of age, as a caretaker. While she's in her duties as a caretaker, she took several pieces of jewelry. The value of the jewelry was well over $10,000. From the subject, this defendant allegedly pawned those items. And that was Miss Bateman.
And it's two different.
And then she allegedly worked, these are all up in Pompano, for Mildred Gutterman, who's 96 years of age, as a caretaker. She allegedly stole from her some jewelry, and that jewelry was well over $10,000 also.
We understand the seriousness of the charges. We're not disputing that. What I'm saying is this young lady has no prior record. I think the safety of the community can be secured by a pretrial release with a condition that she not work as a certified nursing assistant until this case is resolved. She's not going anywhere. She's got nowhere to go. Like I said, her family's not going to be able to bond her out. She's going to be sitting in jail until this is resolved, unless the court can find some relief for her.
Okay. Well, the court also considers that this is not an isolated incident. It does look like she was preying on very elderly people. And the fact that she allegedly admits to this through post-Miranda statements, she did pawn these items, so she has received financial benefit from this. And if she has to bond out, the court could only imagine that some of the financial benefit she received, she would perhaps use to help bond her out of the jail. So go ahead. Does she have any priors?
No, Judge.
Okay. Ma'am, so the total alleged take was about $20,000, and the money is unaccounted for as the result of going to the pawn shops, from what I can see. Ma'am, I'm gonna set your bond on these counts at.
Upstairs at 7:45 to make sure he can
just
get
trying
it. Because I wanted to have extra time to read through the paperwork just in case. Thank you. I'll text you on.
One moment. Ma'am, I'm going to reduce your bonds. I'm going to give you credit for the time you've been here, but I also take into consideration this isn't isolated, allegedly. The strength of the case, you allegedly admitted to it. And the fact is that there's probably some of the money still out there that can be used to bond out with. But I'm going to order no contact with Ms. Gutterman, no contact with Ms. Bateman, directly, indirectly. I'm going to order you're not allowed to work as a caretaker of any elderly people. No one over the age of...
Well, I would ask just...
Going to use an age? Go ahead.
Well, and you can probably go with the age of the statute. I guess anyone over the age of 65, but also anyone with any...
mental infirmities. Sir, ma'am, I'm going to order no one over the age of 65 you're allowed to be a caretaker for, or anyone who's got a mental infirmity. All right, ma'am? No, so what I'm going to do is I'm going to set your bond, ma'am. $3,500 on count 1. Count 2, 3, and 4, 1,000. Count 5, 6, 7 will be 1,000. Count 8, that will be 3,500. 9, 10, 11 will be 1,000. Count 12 will be 3,500. 13 and 14 will be 1,000. You can bond out of jail, ma'am. Thank you. May I see Jennifer St. Jean?
North Broward, Judge.
Her bond's been posted. Thank you. Miss St. Jean's bond's been posted. Thank you, Miss St. Jean. May I see Jean Cruz, Julia Giltz, Jones. There you go.
Jean Cruz bonded, Judge.
Got it.
Giltz Jones is at North Broward.
Okay, ma'am. You are charged with possession of a scheduled drug. Count 2, alprazolam. 3, clonazepam. 4, cocaine. 5, cannabis. Quick finds probable cause. Do we have any priors on Miss Julia Giltz Jones?
One moment, Your Honor. I understand, but do you have anything? One moment, Judge.
Ma'am, are you currently employed?
I work, yeah, I'm a caretaker.
Okay, do you have any money in the bank?
Check with the case.
No.
Okay.
Judge, she has possession priors. Would the court consider pre-trial release? Due to the non-violent nature.
Ma'am, the court's going to set your bond on count 1, 2, 3, and 4 at 1,000. Count 5, 100. Based on your criminal record, the facts of the case. Thank you, ma'am. Okay.
What?
Your bond is 4,100. Thank you.
Thank you.
Roy Thompson, Danny Copeland, David Archer, Corey Mathis.
Enough, guys. Enough.
Where's
This
Roy
is Thompson, Judge.
Thompson.
Thompson. Yes, sir.
Sir, do you still live on 13th Street in Fort Lauderdale?
Yes, sir.
I'm going to release you on your own recognizance, but sir, I'm going to make an order for the next 90 days. You're not allowed to have any alcohol before 5 o'clock in the afternoon, all right? You're not allowed to have a drop of alcohol before 5 o'clock in the afternoon. Do you understand?
Yes,
For
sir.
90 days. I read this and it said 10 o'clock in the morning you were drinking beer and yelling at people. So 5 o'clock, you got to wait till then before you touch anything, all right?
All right, sir.
All right, take care. I'll release your ROR.
Good luck with that, man.
So,
Off you go.
Right. Well, yeah, that's 5 o'clock Eastern Standard Time, sir.
It's always 5 o'clock somewhere, Judge.
Yeah, I know. I believe there were people in the courtroom who knew that, and I reminded me. All right?
Danny Copeland is bonded, Judge.
Okay.
This is Mr. Archer.
And Mr. Assal would have said, you know, I just checked Guam. And it's 5 o'clock. All right. David Archer.
President of the Maine, he's interested in playing if the court is so inclined.
Okay, let me look. Trespassing. It says you're from Loxahatchee.
Corey, your
Liquor store.
Corey,
He's been arrested multiple times for trespassing.
Sorry.
Same place. So, when was the last time Archer was in?
Last time.
Archer, are you currently employed?
No.
Do you have money in the bank?
No, sir.
Yeah, well, that's what it was. June 27th.
What was he in for, June 27th?
Yeah. Trespass, same place.
Trespass, same place? Got it. What about before that?
February 6th.
What was that for?
Capious on an open container.
Okay. Okay.
Hello.
Sir, today, Mr. Archer, I'm going to set your bond at $100. And I'm going to let you bond out, remind you not to go back to the quick liquor store. You're not allowed to go back there. Do you understand that, Mr. Archer?
Yes, sir.
Thank you.
He'll bring you back in about a week and he'll let you resolve it.
Okay. What about Corey Mathis?
1990.
Corey Mathis?
Cell phone.
Possession of cannabis, license suspended.
No, this is not Corey Mathis, Judge. Corey Mathis bonded, Judge. This is Mr. Grab.
Yeah, cell phone should be 5
Got it. Harry Grab.
Judge, Mr. Grab is president of the Maine. He declined the PD. John Marn is his attorney. Mr. Marn is aware of Mr. Grab's presence here this morning.
Mr. Grab, count 1, possession of PVP, also known as FLACA. 2, 3, and 4 are traffic criminal cases, 250, 550. Thank you, sir.
Hey, here's the
Spanish.
traffic tickets were lifted.
Missy Eddie Fleitas Pena and Urbano Cabrera Alejo. Where's Eddie Fleitas Pena?
North Broward.
Got it. Okay, sir, do you swear or affirm to translate from English to Spanish, Spanish to English, truthfully to the best of your ability?
I do, Your Honor.
Mr. Fleitas Pena, you have been charged with violating probation.
Señor Peña ha sido acusado de quebrantar la probatoria.
You'll be held without bond.
Va a ser detenido sin fianza.
You see your judge on July 13th.
Va a ver su juez el 13 de julio.
Thank you.
Gracias.
Urbano Cabrera Alejo.
He's president of the Maine, Judge.
Sir.
Is that you? You're Cabrera?
No.
Sorry. Who are you?
Sir, you're being held for grand theft for $1,000.
Está siendo detenido por hurto mayor en un monto de $1,000.
Count 2 and 3 are warrants for your arrest.
El segundo y tercer cargo son órdenes por su arresto.
They're both no bond.
Ambos son sin fianza.
Thank you, sir.
Gracias, señor.
Will the court indulge me real briefly, Judge?
Sure.
First of all, we need a medical screen for him. He's complaining of some sort of ailment that needs to be seen by a doctor right away.
Que tiene que verlo un médico porque tiene planeado una revisación y está enfermo, así que tiene que ser visto por un médico urgentemente.
And if you could please advise him that Sarah Singer is his attorney on counts 2 and 3, and she has been notified of his arrest.
Que su abogada Sarah Singer ha sido notificada de su arresto y ella es su abogada para los cargos segundo y tercero.
I'm going to order a medical screen for Mr. Cabrera Alejo as soon as possible. Please expedite this. Thank you.
Por favor, lo antes posible,
Thank you,
ordeno
Judge.
que haya una revisación médica para el señor Cabrera Alejo.
Thank you.
Gracias.
You want to make an announcement for Spanish?
I have one more. I have Saddam Silveria, page 19 of the docket. He is here for fraud, uttering a false instrument.
Está aquí por fraude o emisión de un instrumento falsificado.
Okay, just give me me a moment.
Un
His
momento,
last
por
name
favor.
is Silvera, got it. Okay. Sir, you're here for fraud.
Señor, está aquí por fraude.
You're allegedly tried to cash a fraudulent check for $5,200.
Alegadamente trató de cobrar un cheque fraudulento por $5,200.
One moment, Judge.
Un momento, su señoría, dice el fiscal.
He has.
Are you currently employed, sir?
¿Actualmente tiene empleo, señor?
¿Puedes repetir?
Si actualmente está empleado.
Sí, estoy trabajando.
Yes, I'm working.
What type of work is that?
¿Qué tipo de trabajo es?
Estoy trabajando en hotel, en una cocina.
In a hotel, in the kitchen.
Do you have money in the bank? Go ahead.
¿Tiene dinero en el banco?
No.
No.
Out of Dade County, 2013, resisting without violence.
Okay.
Del condado de Miami-Dade, 2013, resistiendo sin violencia, hay un cargo.
And out of Dade County, 2011, aggravated battery on a pregnant victim.
Y en el 2011 también del condado de
$1,000
agresión agravada sobre una mujer embarazada.
Based on your criminal record, the facts of the case. Thank you.
Basado en sus antecedentes y los hechos del caso, su fianza es $1,000. Gracias, señor.
Thank you, sir.
Gracias, señor.
¿Puedes repetir que no oí?
$1,000 bond.
Una fianza de $1,000.
Thank you.
$1,000, gracias.
About Paul Ryan. Who's the Spanish speaker over there? Do we know?
Judge,
The deputy did call.
there was one at North Broward, Judge. Eddie Fleitas Pena.
Paul Ryan, do you have a Spanish speaker over there?
No, Your Honor, I don't.
Okay.
I got a regular mic.
You want to make an announcement?
Yes,
for Spanish?
¿Alguien más en la sala requiere intérprete en español?
No takers at the main, but I believe you have one at North Broward, Judge.
Well, North Broward, do you have a Spanish speaker over there?
Is there anyone over there?
No?
No.
Let me call one at a turn. Isaiah Guzman Tavares. There's only one I think would be it.
Main jail?
Sir, do you speak
No.
English?
Yeah.
Okay, thank you.
Yes, sir.
Sir, you're here for fraud. Court finds probable custody. Do we have any priors on Guzman
One moment, Judge.
Tavares? Sir, are you working now, Mr. Guzman Tavares?
Yes, sir.
What type of work do you do?
Demolition.
Do you have any money in the bank?
Not right now.
Go ahead, Steve. Got it.
Okay. No priors.
Mr. Guzman, do you still live on 66th Avenue in Boca?
Yes, I do, sir.
I'm going to release you on your own recognizance, sir. Thank you.
Good luck.
All right, merci. Brenton McKelveen, Anthony Brand, Cecil Richards, and Joel Geddes. Please line up if I called out your name. Call out your name, line up. Thank you. How about McElveen? Possession with intent to sell, deliver PVP, drug paraphernalia, and trespassing. Court finds probable cause. Steve, do you have any priors on him?
Yes, Judge. Priors include last year, possession of marijuana, resisting without violence. Another resisting without violence last year, resisting without violence 2010. 09, aggravated assault on a law enforcement officer, reckless driving, DWLS. 09, theft. 09, trespass.
Okay, so, sir, are you working?
Do you work right now?
Some side job like washing cars.
Do you have money in the bank?
No, sir.
I'm going to say your bond based on your criminal record. The facts of the case count 1's 1,000. Thank you. How about Anthony
All right.
Brand?
Ron bonded, Judge. Cecil?
Brand bonded? Okay.
Brand?
Probably
Okay.
cause found. Throwing a missile into a dwelling, sir. Quick finds probable cause. we have any priors on this gentleman?
One moment, Your Honor. I'm checking that right now.
Page 18, get it? Yes. You're next.
Richards.
One eight.
I have prior arrests, but no dispositions, Judge.
All right. Sir, how long have you lived down here in South Florida?
10 years.
What do you do for work right now?
Real quick.
Not working right now.
No, do you have any money in the bank?
No, sir.
Okay. Sir, based on the facts of the case, I'm going to set your bond at $1,000 and we'll let you bond out, all right?
Yes, sir.
Joel
Thank
Gaddis.
you.
Good luck. Main jail.
Yes, Your Honor. Mr. Gaddis, petty theft. Quick finds probable cause. It says your third offense.
Michael Cross. Michael.
Are there any priors on this
You're
gentleman?
next. What do you want to ask me?
How long was he in?
Oh.
Anything else? Felony petty theft. Anybody all at a Collier?
No, sir.
Lee? Which one was Lee County?
Private attorney in that court. Yeah. Reset. Okay.
All right. You're welcome. No problem.
You're Michael, right?
All right, sir. Sir, you currently employed?
No, I am not, sir.
Do you have money in the bank?
I do not.
All right. I'm going to set your bond today. It looks like you have 1, 2, 3, 4, at least 4 prior thefts, maybe more. I'm going to set your bond at $750. Do not return to Walmart. Thank you, sir.
Okay. Good luck. Out you go.
I have to come up with what?
$100.
How about Michael
Judge,
Cross? Michael Cross.
Mr. Cross, he has indicated an interest in hiring a private attorney. Would ask the court to reset this to tomorrow afternoon to give him an opportunity
I'll
to
do that.
secure their services.
I'll set it
Thank
for
you.
Friday
Proceed tomorrow.
PM. How about Coel Boone?
Go over there now.
Hold that paperwork.
Cole Boone? Yes.
Mr. Boone, you're charged with license suspended count 1. Count 2 is a probation violation. Give me a moment, Mr. Boone. Yeah, looking at your driving record right now, it looks like your license has been expired since 2011. I'm looking at there's a judgment against you right now that's causing a suspension. Well, no, he is a habitual traffic offender.
So 3 Mondays.
But you know what? That habitual traffic offender could have come off by now. You could have gone and had it reinstated. What is he on probation for?
Same thing.
Same thing, all right.
Out of Hendry County.
Sir, count 1, $750. Count 2, no bond. Thank you. How about Marvin Arias, Brashad Scott, Elliot Roberson?
No bond. You're going to
Watley Nordellis.
You're going. This is Arias.
Mr. Arias, fraud regarding a cash deposit, bank item, quick funds probable cause, allegedly you wrote a bad check or tried to cash a fraudulent check for $4,100. Go ahead.
No priors, Judge.
No. Mr. Marvin Arias, are you still living in Cutler Bay on 81st Court?
27.
Okay, Marvin Arias, are you still living on 81st Court?
Yes.
Yes, he is, Judge.
And are you in school? Are you working, Mr. Arias?
Working or are you in school?
Both.
Where do you go to school?
Where do you go to school?
I go to school at Miami-Dade College, and I work at McDonald's.
Okay, I'm gonna release you on your own recognizance. You're gonna have to come back to court, all right?
Good luck.
How about Rashad
No
Scott?
sentence. You're going to get a court date and you're going to have to come back to court.
Mr. Scott, false
This is
ownership of
Mr.
pawn
Scott.
items, dealing in stolen property. Count one's 1,000. 2, 3,500. Count four is a warrant on a misdemeanor for 2,000. Thank you. How about Elliot Roberson? Elliot Roberson, possession with intent to sell PVP. Count 1, 2, possession of cocaine. 3, paraphernalia. 4, cannabis. For funds, probable cause, do we have priors on Mr. Roberson?
One moment, Your Honor. Yes.
Judge, would the court consider ROR counts 3 and 4?
Okay. His priors include possession of cocaine 2013, sale or delivery of cocaine at or near a convenience store or business. I don't know. Excuse me.
Are they fighting?
Fight going on, right?
Carl. Oh, no, Carl.
Hold on. Okay, sorry about that brief. We had a little bit of a dust up going out in the hallway, which caused us to get sidetracked. All right. So we know he's got a prior cocaine 2013. Court released him R1 3 and 4. And sir, do you have any money in the bank?
No, I don't know at this time.
Okay. So what I'm going to do is I'm going to set your bond on count 1 and 2 at 1,000, 3 and 4 ROR. Thank you. How about
Thank
Watley?
you, Judge.
Watley Nordellis.
Good luck. Watley. Page 20, Watley.
Watley's been.
Mr. Watley, come on. Talk to the judge.
Come on, Watley Nordellis. He's been through a few. Watley Nordellis, possession of PVP, also known as FLACA. Go ahead.
Yes, Your Honor. His priors include.
Recently, Watley was in.
Kevin Kirby.
It's
Kevin?
been recent. I mean, I don't know if he's been on recent on felony charges, but his most recent felony, last year, felony petty theft.
Yes, sir.
He was sentenced to 364 days, July 29th of last year. Possession of cocaine, 2013. Burglary of an occupied dwelling, 2012. Theft, 2012. Trespass, 2012. And he keeps going. Cocaine.
Are you working now, Mr. Nordellis?
Yes, sir.
Do you have any money in the bank?
No, sir.
Your bonds could be $1,000 based on the facts of the case. For the record, thank you. Kevin Kirby, Vernon Roll, and Jeffrey Schmerling.
Yeah, $1,000 to bond out. Kevin bonded, Judge. This is Mr. Roll.
Got it. How about Mr. Roll? Possession of FLACA, PVP. Count 1. State, do we have any priors on this, gentlemen?
One moment, Judge. Yes. Your Honor, he's currently out on bond for grand theft, operating without. 154692 CF10A.
Okay. Sir, today your bond's $1,000. The court will revoke your bond on 154692 CF10. Thank you, sir.
I do not have
Jeffrey Schmerling. Jeffrey
President of Maine.
Schmerling. 2 counts of grand theft, 1 count of petty theft.
For me, please.
1987?
I don't have any kind of report. I don't have anything.
There's not going to be a report, Your Honor, but I mean, as far as PC is based on a validly issued capias, Your Honor. Now, for bond purposes, certainly I can understand the court taking into consideration that you don't have the facts, and that is from the, it's an 87 case.
He was picked up by U.S. Customs at Terminal Lane, I guess. You were picked up at the airport, right, sir?
Yes, sir.
Okay.
Yes, Your Honor.
Understand. Sir, how long have you lived down here in South Florida?
11 years.
Do you still live at Sunrise Lakes Boulevard, number 203?
Yes, Your Honor.
How long have you been at that address?
Approximately 6 years.
What do you do for work right now?
My ex-wife and I she runs a travel agency. I do the website. I do marketing for her part-time. I'm also in Social Security.
Okay. So what I'm going to do is I will release you on your own recognizance today. And you have an open case. You should probably go out and hire an attorney and then come back to court. But you're going to get a note you're going to get something in the mail to come back to court in the next month or so, all right?
Yes, Your Honor. Thank you.
Yes, sir.
Off you go. Good luck.
Thank you, sir. What do I do now?
It depends.
Just go home.
It all depends.
Go home and
go
wait.
back in the cell.
Go back to the cell. They'll tell you what to do next.
Thank you. You might know my daughter, Stacy Schmerling. She's PSO. They put her recently on some hero her child.
Oh, very good.
She's like,
Is he?
I had a background check before this, and all of a sudden I come off the plane, family vacation. Go,
Ryan
what's your name?
Watkins,
Billy.
Ivan Trastek,
Good luck.
Maxine Nelson.
Watkins is a medical reset.
Okay, I'm not gonna reset, I'm just gonna send it straight to the division. Count 1,003, no bond.
God, Patrice. Go away? No.
Fighting?
It's round 2, I think.
Round 2 is right.
Okay, Ivan Trastek.
Main jail.
Sir, operating with no driver's license, count 1. And 3 and 4 are, they're from 1999.
Maxine?
Delivery of cocaine and possession of cocaine. Those are warrants for your arrest. Give me a moment here. Sure, your bond today is $25 on 1, 3 and 4. Those are no bond. Thank you.
Thank you, Judge.
How about
All right.
Maxine
You'll see
Nelson?
Your judge on Tuesday.
Decline PD.
He declined the PD, Judge. President
Possession
Domingue.
of PVP, cannabis, court finds probable cause. Steve, do we have any priors on this gentleman?
When you bring the priors, please?
Possession of cocaine with intent to sell, 2011. Possession of cannabis, 2007.
Okay.
Possession of cannabis, 2004. Possession of cocaine with intent to sell, 2000. Possession of delivery of cocaine, 1999.
Okay. Sir, are you currently employed?
Yes, sir.
What
I'm
type
working
of-
at Publix warehouse. I'm a warehouse person.
How long have you worked there?
4 years.
Do you have money in the bank?
I got like $850.
So I'm going to let you bond out based on your lengthy record and the facts of the case. Your bond's $1,000. Thank you. How about
All right, thank you. Good luck.
Kevin Pasantes?
So change of charge.
Judge, we're clear at the main, so I'm going to go
Broward.
ahead and punch out.
Got it. Thank you. How about go ahead.
I'm getting it right now for you. Yeah, I think what happened was here. No, actually, just one moment.
You should have seen my last one.
It was actually downfiled, Your Honor, from what I can tell. Here, let me. Just want to. It's serious. I just want to be completely accurate. Okay. It basically was downfiled and merged. Originally, it was a burglary with a battery. So he is entitled to a bond.
What's count 1? Pasantes, are you working when you're not in jail?
Yes, sir. I work for my parents' limousine company.
All right. How long have you lived down here in South Florida?
About 17 years.
Do you have any money in the bank?
No, I don't, sir.
Okay. He's only being held on one other count of battery and another count of criminal mischief.
Right.
So, do you want me to print out a report for you, Judge? Yeah. Okay. Yeah, it's printed. Actually, I think you'll remember this case, Your Honor. It was alleged there was something going on with his younger brother and another kid. This is May, and apparently he's alleged to have started going after the other juvenile. There was the other child's mother got an injunction, but there was no proof at the time of this incident that it had been served. So the court found no PC for the first count for the injunction issues and stalking issues. Yes, Judge Lee found proof evident presumption great. Computer's all
Right.
here.
Does he have a criminal record?
No, as an adult, I think he just had a possession of marijuana. I don't see anything else as an adult.
With the monitor, right? So I'm going to order you're not allowed to have any contact with Kevin Suku. Do not have any contact with him. Stay 500 feet from him at all times. It's where he lives, works, goes to school. Based on the facts of the case, your criminal and your lack of a criminal record, I'll give you credit for. Your bond today is $25,000. The court believes you do represent a danger to Mr. Suku based on these facts. It does appear that you continue to go after him and eventually going into his home. So I'm going to order pretrial release, GPS monitor. I'll waive the cost. Thank you, sir. How about Tyrone Dixon, Roosevelt Graham?
It was, yeah. Thank you.
Yes, Your Honor.
Okay, so I'm gonna reset your bond at $5,000 today. Back on pretrial release. Thank you. There you go.
That's me, Your Honor?
Yes, sir. What?
Was that Dixon, Your Honor?
That was Dixon. Thank you. Roosevelt Graham.
Yes, Broward. No problem.
This is also a change of charge. It looks like just the...
Yes.
He was ROR'd on this count originally.
Sure, you're going to be released ROR on count 4. That's what we're here on today. Thank you. How about Derek Ponder?
Policy, Your Honor.
Okay.
Sir, possession of PVP.
Another change of charge.
What is it now?
I'm checking that right now.
It used to be
it was
cocaine, now it's PVP.
Yes, and it was $1,000.
Sir, your bond's going to be $1,000 on possession of PVP. Yes, sir.
Hey, Your Honor.
Yes, sir.
Your Honor, may I have a word? I was on pretrial release, Your Honor. The reason why I ain't never show up to the pretrial release because my grandma was in the hospital about to lose her life, sir. You know what I'm saying? So that's the only reason why I ain't never show up to pretrial release.
Right.
I ain't never missed a court date or none of that, sir. My pretrial release back, sir, please.
No, I'm going to put you on $1,000 bond. Thank you. How about
okay,
Fionn?
so I can bond out?
Yes, sir. Fionn Patrick. Fitzpatrick. Fitzpatrick.
I don't have anything else.
Fionn Fitzpatrick.
Hold on, Your Honor.
Sir, you have a grand theft. State.
One moment, I gotta check. I didn't have any other paperwork. Okay. Yeah.
Deputy Green? Can you relieve Charlie now for Bethlehem?
I just see this not in custody, but I guess also count 2. It wouldn't be in my system. He has a pending theft, even though it's on an MO.
Okay, so I'm gonna leave your bond at $1,000. Thank you. There you go. Is that a wrap, everyone?
I hope so.
It's a wrap. It's a wrap. We'll see everyone back here at 1:30. Thank you.